participants?
Yeah, good evening, ma'am.
I request all of you. Yes, good evening. I request all of you to please keep your mic on mute. If you all are comfortable, you all can keep the video on. The meeting will be recorded, the webinar. We will have the resource person joining with us very soon. In fact, on behalf of School of Law, Ajeenkya D.Y. Patil University, Pune, I welcome all the participants. Our head School of Law, Dr. Sapna Bansal ma'am, will also be joining us. At the outset, let me thank all of you for joining this webinar. We've had a tremendous response, more than 105 registrations for this webinar on gender-biased sex selective elimination and implementation of PC&PNDT Act. It is really a pleasure to have such a composite audience from different backgrounds. Let me give you a brief introductory remark on the webinar's theme that is there. Pertinently, PC&PNDT Act focuses both on prohibition of sex selective elimination at the stage of conception and after the stage of conception. Initially, this act that was there, it was only the PNDT Act, Prenatal Diagnostic Techniques Act. Later on, there was a case filed by Chehet versus Union of India, and an amendment was made, and the word PC was also added. So in its current form, we have the PC&PNDT Act, Preconception and Prenatal Diagnostic Technique Act. Now, all of us have a brief idea about patriarchy as a concept. All of us have a brief idea of son preference as a concept. How women are discriminated against. And that discrimination goes even to being a girl child, right at the stage of whether to be in the womb or not to be in the womb. That discrimination, that denial of right to life is so evident. It is so inhumane, but this practice has been rampant. So many studies have been conducted by United Nations organizations and its agencies. And it has identified a number of factors responsible for this practice. However, pertinently, patriarchy as a value, internalization of violence against women, male-centric society, hypergamy, access to unregulated reproductive technology, they have been the key determinants of why still there is female feticide. There are two concepts out here, female feticide and female infanticide. Female feticide is right in the womb where the girl child, on detection that it is a female fetus, there is a medical procedure and that fetus is extracted from the body. Female infanticide is a stage where after the birth of the girl child, that child is killed. Now, it is not like that. We didn't have provisions beforehand. We did have. We had the Indian Penal Code. We had Medical Termination of Pregnancy Act. Indian Penal Code section 312 specifically spoke about miscarriage, causing miscarriage, and what is the punishment for it. But this practice was still rampant. Medical Termination of Pregnancy Act, which came up in the year 1971, it recognized the right of a woman to terminate the pregnancy under certain conditions. The act has remained for regulation of medical practitioners and for realizing the rights of a woman over her own body. So bodily integrity, bodily autonomy, reproductive rights, reproductive justice, all of that has been achieved by virtue of this act of MTP. But then still, it was found that female feticide is a rampant practice. So the legislature enacted this PC&PNDT Act of 1994. And very recently, there has been an amendment. And it was challenged. In fact, in the year 2020, the resource person, Dr. Advocate Uday Varunjikar sir, will be dealing with that issue also. How the 2020 amendment, what effect it is purported to have. All these issues will be dealt in today's lecture, in today's webinar. We will wait for the resource person to join. In the meantime, I have a few instructions.
Madam, I am here. Madam,
okay.
I am here.
Okay, sir. Good evening, sir. Good to see you. Welcome.
Yes, please proceed.
Yes, sir. You are visible, not an issue, sir. Yes. Good to see you.
Thank you.
Yeah. Thank you for joining us, sir. I appreciate, we all are very honored and privileged that in spite of your busy schedule, I know you've just come from a meeting, you have a meeting after this, Bar Council meetings, and you have still made time and given us this opportunity to hear you. So without any further ado, let me introduce the resource person. On behalf of School of Law, Ajeenkya D.Y. Patil University, I, Professor Kashmira Lonkar, welcome Dr. Advocate Uday Varunjekar, sir. A brief profile about sir. It has been so illustrious. He has more than 27 years of practice. He's recently been awarded the PhD degree from Savitribai Phule Pune University on the topic of Gender Justice, Human Rights, Preconception and Prenatal Diagnostic Techniques Act of 1994, a critical appraisal of statutory and judicial perspective. Sir has previously taught as a part-time lecturer in 2 commerce colleges in Mumbai from 1996 to 2002. He has handled more than 14,900 cases. That is really a landmark. He has been a part in the various public interest litigations. He's handled many of them. He's handled various issues concerning rights of female feticide, rights against right of a female. He's also written 2 Marathi books by name, न्यायालयांचा हवा, न्यायालयांचा Samaj. It was also translated into English. He is also a column writer in Daily Sakal and Lok Satta. He's also participated in various TV channel programs about legal issues on All India Radio. He has been the sole advocate for MHADA since 1998 on certain issues. He has also been invited by Pune University on various occasions. He's also invited by Bharati Vidyapith, Mumbai University. He has been a resource person for training of all judicial officers in state of Maharashtra. He is also the recipient of the Ethical Legal Practitioner Award from Trans-Asia Chamber of Commerce. He is also a recipient of the award from Mumbai Grahak Panchayat for valuable contribution in protection and promotion of consumer rights. And Let me tell you, his this is goes on and on and on. It's such an illustrious career. Thank you, sir. I would want the participants to listen more to you. So I welcome you again. Over to you, sir.
Okay, thank you, our classmate of PhD, Professor Kashmira Lonkar. And good evening to all friends from Ajeenkya Patil University School of Law. Uh, I must say that this is the first time interaction with students of this Ajeenkya Patil University. And therefore, I must congratulate you that you have chosen a different path. A much courage is required for choosing a different path. And straightway coming to the issue which has been assigned to me, I must say Maharashtra was the first state in the country who had chosen a correct path. That was 1987. In 1987, our law minister was Pratibha Patil, who happens to be a president of India, and now she had settled in Pune. She was a law minister who tabled a bill before the Maharashtra Legislative Assembly that was known as PNDT Act 1987. What was the situation? Because as a student of law, we will have to correlate between the social situation which was prevailing at that time and the legal developments. What was the situation? Somewhere after emergency period was over, we noticed, and rather entire India noticed, that there was a widespread of the technology which was used in the field of medicine. I'll repeat. The technology which was there used in the field of medical, allopathic treatment or otherwise, there was a complete new kind of a technology which came. And it was popularly known as a sonography. That sonography technology was new so far as all Indians are concerned. And then because of that, in some parts, the advertisements were getting displayed. Those who are having a background of Mumbai, they may ask their senior persons from the family. In a local train of Mumbai, which is a lifeline of Mumbai, there used to be some posters which were posted inside the railway compartment. And it was passing a simple message: spend 500 now, save 5 lakhs. And then the number. And upon making an inquiry, what was being told? That it's a sonography center which is there, where the charges are rupees 500. They will detect the sex of the fetus in the womb. And if they find that it's a female, then they will advise you to terminate the pregnancy, and then you can save the expenses on the marriage. That kind of a complete project was there. These were the advertisements which were published at that point of time, and Professor Kashmira made a reference correctly to the patriarchal system which we are following. An entire country was not an exception to that. As a result of that, Maharashtra was the first such a state who came with PNDT Act 1987. But of course, that was having some shortcomings. And as a result of that, hardly 1 or 2 cases were filed under that particular legislation. That was 1994 was the year when the central government adopted the formula of the state of Maharashtra. We are very proud as a student of law from the state of Maharashtra that there are several such legislations which are copied from the state of Maharashtra formula. Though it's a little deviation from the original topic, but as a student of law, let me tell you, you will find at that point of time, the Roha Yo was there. It's a Marathi word. Rozgar Hami Yojana. And now the central government came with an enactment based on that. That is known as Employment Guarantee Scheme, and then Manrega is an act which has been introduced. This goes to show that how state of Maharashtra was a progressive even at that time also. Let us go back to 1994 when the amendment was made by the state of Maharashtra, which was a fourth state in the Hindu Succession Act, which gave equal right to female as if she is equivalent to the son. And we are aware that in 2005 the central government enacted the amendment in the Central Act, and therefore it has been made applicable to the entire country. So coming back to the main theme, that there was an enactment which was again based on 1987 formula, 1987 scheme, but a petition was filed in the public interest before the Honorable Supreme Court, in which several new dimensions were introduced. And we are aware as a student of law that there are n number of such occasions when, because of the petitions which are filed before the High Court or the Supreme Court, the laws are getting settled or they trigger the amendment in the legislation. We are aware that the Honorable Supreme Court was kind enough to issue different judgments from time to time, which were law of the land till the amendments were made or the enactments were made, like Madhuri Patil, where the caste certificate issue is there, or even Vishakha, where the sexual harassment at workplace is there, and then so many things which can be added into the list of all those judgments and directions. But this was a direction where Justice Shah from Gujarat cadre, who happened to be the Chief Justice, the then Chief Justice of Bombay High Court, Justice M.B. Shah was presiding the bench of the Honorable Supreme Court. Justice M.B. Shah's bench directed the government to consider the suggestions which are made by the civil society, who pointed out that there are some loopholes and the drawcomings in the system and the legislation which was there. The central government considered that, and the act came to be amended. Now the title of the act got changed. That became Preconception and Prenatal Diagnostic Technique in bracket Prohibition of the Sex Selection bracket Complete Act 1994. So in 2002-2003 various amendments were made, and ultimately we are now dealing with the act, which is a gender neutral act and intends for protection and promotion of the gender neutrality along with the protection of a gender. Now, we are aware that as a student of law, we will have to compare the social situation with the legal solutions which have been introduced. So what we are going to do now, I am going to suggest you to do a comparison. This may be termed as a homework also. You will find on the online platform, there is a website of the Census India. Please go to that website. You will come to know that 1991 census is also there. 2001 census is also there. 2011 is there. Now, so far as 2021 is concerned, it has been delayed. And some wise and enthusiastic persons from the civil society, they started making a comparison of the census data of 1991 with 2001, and they found that there is a tremendous reduction in the number of daughters. They call it as missing daughters, and there was a separate information which was provided in the census report that these are the large number of daughters which have gone missing, and then automatically the further progress started. Why these large number of daughters have gone missing? What is that reason? And then it was realized that the spreading of the technology and the mindset which Professor Kashmira made a reference, that has worked adversely. And what is the impact? Impact is the sex ratio of the society has got disturbed. What is this sex ratio? There are two types of such a statistic. One statistics is with reference to sex ratio at birth. Namely, if 100 male child are given birth, then how many female childs have been given birth, and then compare that. Then that comparison will be made throughout the country, throughout the state. States can be compared against one state to another state. District can be compared, the rural part can be compared, and since we are in Pune, then the wards can also be compared because those data were available immediately and readily. The second is the child sex ratio, which means the child reaches the age of 6 years, then the child becomes eligible for the first standard admission. This was prior to NPS, new education policy, NES. So therefore, as a result of that, 6 was the year when it was also considered as one of the yardstick, and then the calculation was made. But by making comparison, it was found that crores of daughters have gone missing. Then of course several persons tried to find out what is the reason, and then we are having a habit of blaming different problems which are persisting for last several years, like no, nothing is happening in state of Maharashtra, this must be a problem because of the Bihar or Uttar Pradesh or Rajasthan or Madhya Pradesh, and those persons who are comparatively backward as compared to state of Maharashtra, they may be having a problem. The problem is not in the state of Maharashtra. That kind of the first reaction was there. Then it was pointed out that sorry, if we trace on the map of the state of Maharashtra, then we will find that in the well settled belt, which starts from Jalgaon, then Nasik, then Aurangabad, Jalna, Ahmednagar, Pune, Satara, Sangli, Kolhapur, Solapur. This is that central belt of Maharashtra, which is comparatively a fertile belt. Comparatively, the persons are from the well-to-do family. These are the persons who are facing the challenge, and these are the persons who are having access to the technology. Because once we realize that these are around 10 districts where the problem was there about the missing daughters, then somebody tried to link this with the technology, and therefore wherever there was an access to the technology, the sex ratio disturbance was noticed. It was also noticed that go to Gadchiroli, go to Bhandara, go to Gondia, go to Sindhudurga, go to Ratnagiri, or go to even Palghar, you will find that there was no immediate access or easy access to the technology because of the less number of the centers and less number of the techniques and less number of the technicians. As a result of that, there was no such a disturbance of the sex ratio. No doubt the mindset which was referred by Professor Kashmira was also one of the factor which ultimately resulted into elimination of the daughters and the sex selection of the fetus. So therefore, somebody tried to correlate all these issues, and ultimately it was pointed out before the Honorable Supreme Court that, sir, now after liberalization, namely 1991, we have opened the doors for the world at large, and now there is a complete new access of technology which is available, which is online access. So therefore now the information is available online, and people are not trained how to use that information. Young friends, I must tell you, there is a vast difference between the information and the technology. I'm sure you must be meeting Google Mousy every day. I'm sure that Google Mousy is situated in your own mobile. If it is an Android mobile, then that Google search engine is that Google Mousy. She will help you every time. But don't forget, that is an information and not a knowledge. But nonetheless, that information will be available to everybody. But the sensible netizen like all of you will not use that information unless you understand that information. Let us become a responsible netizen, understand that concept, and then based on which we can take a further decision. Let us come back. So therefore now, based on which a act was amended, the object of the act was further amended, and I will read that object clause for all of us. The object clause after the amendment says an act to provide for prohibition of the sex selection, comma, before or after conception and for regulation of prenatal diagnostic technique for the purpose of detecting genetic abnormalities or metabolic disorder or chromosomal abnormalities or certain congenital malformation or sex-linked disorder and for the prevention of their misuse for sex determination leading to female feticide and for matters connected therewith or incidental thereto, full stop. Oh my God, what a lengthy object. But don't be afraid, young friends. When I was a student of law in my law school at that point of time, like you, our professors have taught us a very simple technique. And that technique I am using as a student of law even today. Let us bifurcate this entire lengthy definition into small pieces and let us try to digest this. On the same line, let us try to bifurcate this object clause into small pieces and let us try to digest it. The first is an act to provide for prohibition of the sex selection. So what is an object of this enactment? Sex selection is to be prohibited. So of course, what is the meaning? Sex selection means select out of two. Out of two means either male or female, you will have to choose one. So that is to be prohibited. Now the next sentence is before or after conception. We know the word conception. Conception word is Marathi, it is known as Garbhadharana. So therefore, before conception or even after conception, sex selection is possible. Because the original act of 1987 of State of Maharashtra or 1994 of the Union of India, that was the conception, post-conception centric. Namely, the technology which was used for the purpose of the detection of the sex was used. In other words, sonography was the technology which was at the center of that enactment, and therefore the legislation came with the new concept, namely even before conception, sex selection is possible. Let us go back to the history book. That was somewhere 1975 when Calcutta was the city in which the second child in the country, in the world was given birth, and the first daughter was given birth by using a test tube baby technology. That test tube baby technology is again a science. Nobody said that science is wrong. Nobody said that technology is wrong. But there are persons who are using this technology for wrong means, for wrong purposes, and those are the persons who are required to be passed a strong message. So therefore, before conception it is possible. And for what? The act says that regulate the technology. So say next sentence, for regulation of prenatal diagnostic technique for the purpose of detecting, etc., etc., etc. Let us keep those medical terminologies. So the another object of the act is to regulate the technology. You must have seen that I am again and again saying that technology is not wrong, but the person may use that technology for a wrong purpose, and therefore the regulation of the technology is required. Let me give a simple example. You know the matchstick. In every kitchen, you will find, though you are using a lighter, but despite that, there will be a matchstick. What is this matchstick? Matchstick is again having a technology. Matchstick is based on the science. We are aware that there will be some kind of material which will be at the one end of that stick. There will be paraffin layer on that stick, and then once there is a friction, there will be a fire. That fire will be continued till the end of that particular matchstick. This is that technology. That technology and that science can be used for setting her on fire for commission of an offense, and the same matchstick can be used for the purpose of lighting the lamp. Nobody says that that technology is wrong. What is the knife? Knife is again based on the science. We are aware that the experts in the criminal case, they will tell you which weapon was utilized and who has stabbed the witness or the deceased person. What is a firearm? Firearm is again based on the technology. There are experts who will tell you how that technology was used in a commission of an offense, whether the person who used was sitting at what distance, whether the injury is prior to death or after death. All these answers can be given by analyzing the that particular weapon, that particular evidence based on the technology. So coming to that conclusion is that nobody is saying that technology is bad. Nobody is saying that science is wrong. But the persons who are using that particular science or the technology, they may commit a mistake, and therefore the regulation of that particular technology was required. So the second object is regulation of prenatal diagnostic techniques. Now for what purpose? That says for prevention of their misuse. So the third aspect, third object would be preventive. We have seen the first object is prohibition of the sex selection. Second is regulation of the technology. Third is prevention of misuse for sex determination leading to female feticide. Now let us go back to the history books. When Hitler committed rather tried to eliminate the Jew race, we have never used the words that he committed murder. We use the word genocide. So on the same line, you will find the terminology is female feticide. Namely, if this technology is used for the purpose of eliminating the child, which is a girl child, then it is known as a female feticide. So therefore, these are the objects. So now let us try to find out what are prohibited. The first is sex selection is prohibited. We are aware about that. The second is sex determination is prohibited. This is that second object which came, second amendment which came after the amendment made in the year 2002-2003. Namely, even prior to conception, because of the technological advantage, the sex determination is possible. Let me tell you, as a student of law, you might have come across some advertisements which are available on the internet, that there are some laboratories who can choose the sex of the child. The advertisements are, we pick Y and deliver boy. Let us go back to the science. We have learned in the biology that 23 genes are there in every human being, out of which one part of the 23 comes from father's side and another 23 comes from mother's side. And in the DNA matching, this is that evidence which is used. So therefore, we are aware that this is possible. So therefore, now based on that, they said that if we pick Y, then based on that picking up Y chromosome, we can deliver a boy. Now you must have come across a new concept of a designer baby. This is that new concept which is likely to come in the India in the near future. So this is the situation which was required to be handled, because this is going to create such kind of impact on the entire society. Let me tell you what was the statement of object and reason when the act came to be amended in the year 2003. I'll read one paragraph which will make it clear why the legislators were intending to amend this. It says prenatal diagnostic technique like amniocentesis and sonography are useful for detection of genetical or chromosomal disorder or congenital malformation or sex-linked disorder. However, amniocentesis and sonography are being used on the large scale to detect sex of the fetus and terminate pregnancy of the unborn child if found to be female. Techniques are also being developed to select the sex of the child before conception. The next sentence is most important. These practices and the techniques are considered discriminatory to the female sex and not conducive to the dignity of a woman. This is that particular message which I wanted to pass. Para 3 says, the proliferation of the technologies mentioned above may in future precipitate a catastrophe in a form of severe imbalance in the male-female ratio. The state is also duty bound to intervene in such matters to afford welfare of the society, especially of the women and children. It is therefore necessary to enact and implement in letter and spirit a legislation to ban preconception sex selection technique and the misuse of prenatal diagnostic technique for sex selective abortions, and to provide for regulation of such abortions. So this was that object which was mentioned in the statement of object and reasons. I must tell you, apart from reading the object clause, as a student of law, we will have to read the statement and a statement of object and reason which is tabled along with the bill on the platform. That will give us some idea as to why the act was enacted. as well as why the amendment was made in that particular section. So therefore, section I was pointing out about the prohibition. One is sex selection was prohibited. Second is sex determination was prohibited. Third was with reference to the advertisements which were misleading, as well as which were dealing with this issue, that is also provided. And I must tell you, as a student of law, you will find that very few legislations are there which deal with the provisions of creating an offense relating to an advertisement. As a homework for all of you, you can make a list of different legislations where advertisements have been made punishable. You will find the list will not go to even double digit. Indecent Representation of People Act, Food and Cosmetic Act, Drugs and Magic Remedies Act. You will find that Tobacco Act. You will find that several such legislations are there, but that will not go to even double digit. This is that enactment by virtue of which section 22 provides that there is a prohibition of the advertisement relating to the preconception and prenatal determination of the sex and punishment for contravention. Even the advertisement on internet was also prohibited in this act. This is that 2003 amendment. Let me ask you a simple question. Whether in 2003, whether all of us were having a mobile at that point of time, you will come to know, no. Some of us were having a landline at that point of time. They were not having a ordinary telephone also, the ordinary mobile phone at that point of time, much less a Android telephone. But the legislators or the legislative draftsmen are the such persons who will have to see what will be the requirement of the country or the society in near future. Those were the persons who will have to consider the situation and then accordingly make an amendment. So in 2002-2003 amendment came to be made, which is prohibiting the advertisements on the internet. This is that beauty of that. Now, apart from that, the act also says that there is a ban on communication of the sex of the fetus by words or sign or otherwise, and the communication to the pregnant mother, their relative, or any other person is banned. You will find there are several stories which are related to this. I'll not go into detail, but you can get those stories on the internet also, and those are some kind of the novel ideas which were adopted from time to time to defeat the provisions of that. To give an example, I'll add only one. I'll mention about one. The sonography machine you must have seen. If not seen, then I'll give you an illustration. There is a screen like what screen which you are using now. There will be a CPU like the computer CPU. There will be keyboard like our keyboard, and there will be a probe. Probe is something like a mouse. That probe will send waves in the womb of that mother, and then wherever those waves will get obstructed, that will catch that picture, and the picture will be seen on the screen. You must have seen this kind of machines. Now, this is that basic technology. These technological machines are situated in the center. Center is having two arrangements only. One is for that machine, and the second is for lying down of that patient. The patient will lie down on that platform, and then maybe one assistant will be there to assist that technician. So maybe around 4 feet by 6 feet, or even 6 feet by 6 feet will be a space which is required for conducting this test. And despite that, the law said that there should not be a communication of the sex of the fetus by words or by otherwise. And then the novel idea came that the doctor on the one side has kept one a photograph. There will be a photograph of Jai Mata Di, and on the other side there will be a photograph of the Satya Sai Baba. And whenever the doctor or the technician who is doing that sonography, if he comes across the information that the child is a female, he will only say Jai Mata Di, communication of the sex of the fetus takes place. If you find that there is a male child in the womb, then he will say Jai Satya Sai Baba, communication of the sex of the fetus will take place. And as a student of law, let me ask a simple question to all of you. How are you going to prove this? As a student of law, we are aware that we need a ocular evidence, we need a documentary evidence, we need circumstantial evidence, or some evidence should be there. How are you going to prove this? In Hindi, it is said that Mia Bibi Raji, to kya karega Kazi? So therefore, the person who is willing to undergo the technological test is ready. The person who is going to provide that test, he is also ready. The family of that pregnant mother is also ready. On some occasion, we have seen that the mother, who is a pregnant mother, was pressurized by the family members to deliver a child of a particular sex. These are the things which we can't omit, which we can't ignore. And therefore, you will find that the law was made with a intention to provide documentation based offense. You will find the regulatory object which was there, that said, that provided a necessity to obtain a license before using this technology. Now somebody may say that, sir, why license is required for using a technology? Don't you think that you use a technology every day while driving your vehicle? We are in Pune, so Ajeenkya D.Y. Patil College, D.Y. Patil University School of Law, all those students are using their two-wheeler or four-wheeler from to reach to college from different parts. So therefore, they are using the technology. That technology needs a registration. So why not register with reference to this technology? They also said, the Act also said that if you are going to use this technology, then you will have to maintain some record of the mother, and that record will have to be maintained in the format which is provided under the Act. Why? Because they again started making a complaint that no, we are the technicians, we are highly qualified. Why we should be reduced as a clerk for the purpose of maintaining that record? But the legislator said that sorry, this is an offense which is against the society at large, against the humanity, and therefore we are saying that maintain the record. And there was a provision which was made for the purpose of making an audit of those entire record. You will come to know that surprising things took place. There was a hospital in Pune, near Pune railway station. It was found during the inspection that all pregnant mothers who were sonographed on that particular day, they were showing the same address. Same address means the same lane. Somebody may say, sir, what is wrong with that? The wrong is this, that it is virtually impossible that all those 100 pregnant mothers from the same area became pregnant on the same day, and they came at this state, at this center. That created a doubt about the genuineness of that record which was maintained. And when it was tried to trace whether those mothers are genuine or whether those are fake entity, this committee, supervisor committee, found that all were fictitious names. So therefore, the record-based application was introduced under this Act. Apart from that, in some cases, it was a burden of proof which was shifted on the doctors, because the legislators were aware that nobody is going to come forward for giving an evidence against the doctors, or the mother is also not going to support the this enactment because she must have been pressurized by the family members. So therefore, with reference to that, the arrangement was made by the legislators by virtue of which the burden of proof got shifted. Now the burden is on an accused. The accused will have to prove that there was a accuracy in the record which was maintained by them. Now the offences were introduced. Now the offences were punishable. And for second or subsequent offence, aggravated punishment was also introduced. Most important aspect is this, that during pendency of the trial, the license to practice was directed to be suspended. You will find state of Maharashtra and the Rajasthan. These are the two such states in the country where large number of suspension of a license to practice, which are granted under the Indian Medical Council Act, are existing. Hundreds of technicians and the doctors were facing such kind of action by the medical council. Some of them lost their registration also. That goes to show that the act was made in such a manner that it is virtually applicable, and it was virtually made into a positive direction. Now, apart from that, there was a presumption which was created, presumption to protect the pregnant mother, because we don't want to face such a situation that the mother will be further harassed for undergoing such technologies and tests. You will come to know that in the state of Maharashtra, in Sangli district, there was one more case which was registered against the husband. Husband was shown as an accused because the mother gave a statement that she was pressurized to undergo this technology, and she was told to go for abortion since the mother in the womb, since the child in the womb was a female child. So therefore, against the father of that unborn child, this kind of a case was registered. This was a unique case. I must tell you that as a student of law, I am one of the public prosecutor or the special public prosecutor who has secured maximum number of conviction under this act in the state of Maharashtra. I am very proud to share with you, I am a person who has handled maximum number of PIL under this act. You will come to know that I am a person who has contributed in several reported judgments which are under this act. Having said about this, I must also add that I have got an opportunity to educate the young batch of the students like you who are student of law. Not only that, the judges and the public prosecutors and the different other officials which are there. After having a large experience with reference to this, let me tell you, the act is not complete in itself. The act requires further amendment. Act requires further kind of one more step, because you will come to know that the act is having some small loopholes which are now being exploited everywhere. You will find with reference to the genetic counseling centers as well as genetic laboratories, there is no effective implementation. You will find that with reference to test tube centers or the other such centers where the tests are conducted, there is no effective implementation. As a result of that, you will come to know that that is that area in respect of which a further steps are required to be taken. You will come to know that there are sperm banks, there are egg bank. Likewise, you will find that there are such centers who are giving you composite facilities, namely a center which is registered under the provisions of MTP Act and a center which is providing the other facilities. Those are virtually not covered effectively under the scheme of this act. Now, other than sonography centers, there are other technicians who are using the technology. Those are again not covered under the act specifically. That will have to be brought within the framework of that. I must tell you, this is not a full stop with reference to change of mindset. Somebody may say, and rightly said by Professor Kashmira Lonkar, that the male preference mindset of the Indian society, that is the biggest problem. I agree with that. But changing the mindset takes years together, maybe 100 years. We are aware that with reference to the remarriage of widow or for giving equal right to daughters as if she is a son in the ancestral property, it took years, generations after generations. We are required to wait. Are we going to wait till those generations are, and after generations? Are we going to wait for another 100 years? No, it is virtually such a situation that do or die will be the situation. In Rajasthan, you will come to know that there are certain villages where no Bharat has come for the purpose of marriage because there was no girl which was born in that particular village. You will come to know in India, Yamuna ke par is a phraseology which is used for the purpose of the other side of Yamuna. We are aware that Uttar Pradesh and Bihar is divided into two states. one bank of the Uttar Pradesh, one bank of the river Yamuna is settled comparatively as compared to another, and the girls from that area are brought in the Punjab and Haryana and even Rajasthan for the purpose of marriage. This is the ground reality. You will come to know in certain religions, this problem is aggravated. In certain castes among the Hindus, this problem is further aggravated. There is no need to mention with reference to all those different castes or religion. Suffice to say that the problem is persisting even today. Problem is very serious, and we as a student of law, we will have to find a solution. Otherwise, what is going to happen? Otherwise, the law will remain on the paper, and tomorrow perhaps there won't be a girl for the purpose of marriage. You will say that, sir, there is a choice. Somebody may say that I will not get married. All right, that is your choice. Don't try to say that. Dr. Uday Varunjekar tried to say that you should get married. I'm sorry, there I am not at all saying so. And one more interesting issue which came in my mind: can there be a right to perform a marriage? Can there be a right to have a balanced family? If it is, then tomorrow somebody may file a petition against the Union of India or the state of Maharashtra saying that, sir, I wish to get married. There is no girl in our community or in our village or in our area, so please provide a girl for the purpose of marriage. This can't be. This is your personal choice. But the fact remains that you will have to consider the interest of the society. What is going to happen if less number of girls are there? Then it is going to change the entire setup of this entire society. The fabric of the society will get changed. Our mother, our wife, our daughter who will go in the market, there will be a problem. There will be apprehension whether that daughter, whether that wife or the mother or any female from our family, whether she is safe, whether she will come back safe after doing her work. Because you will find that there is nothing mentioned on the forehead of anybody whether he is falling in category A or category B. We are aware that sexual offences are increasing day by day. We are aware that after Nirbhaya, various new provisions have been made. But the fact remains that despite such methods, such new amendment, despite different steps which are taken, the fact remains that the sexual offences are increasing. And if it continues, then there will be a problem, there will be an apprehension, and perhaps the entire social fabric of the society is likely to get damaged. If this is an apprehension, then we will have to take the steps. Let me, in a fast manner, let me add two more concepts. This act is nothing to do, this act is not at all having any connection with the Medical Termination of Pregnancy Act. Because there is a confusion in the mind. This act is independent, MTP Act is independent. MTP gives a monopolistic right to the pregnant mother to go for an abortion. That is a separate enactment which has nothing to do with the provisions of this act. But sex selective abortions are prohibited under the act. Having said about this, let me tell you that in the state, in the entire country, our Prime Minister has also taken an initiative. Beti Bachao, Beti Padhao is that slogan which was given. Different schemes have been introduced, but that is not enough. We as a student of law, we will have to start implementing the provisions of this act. The implementation from the implementation of this act from ourselves will be a solution. And therefore, though it was a full house of the Bar Council of Maharashtra and Goa, where several decisions were being taken for the welfare of the members of the legal fraternity, I said, once I have given time of 4:30 to 5:30 for this Ajeenkya Patil College, University School of Law, I'll have to come here and I'll have to meet all my young friends at that side. Having said about this, now it's a time to wind up. I know it's a time when everybody is eager to meet physically. I'm sure in near future we will meet once again. I don't know when, but I'm sure by that time you will carry this message, you will implement this provisions of the act by whatever manner, and you will give me the feedback on that particular day. With this, I must express my thanks to The organizers, more particularly our friend from the PhD batch, Kashmira Lonkar professor. And Kashmira, it's a pleasure to speak on the topic of my PhD. There are very few persons who get such an opportunity to speak about the topic of PhD. But I must tell you, it was a pleasure which you gave me this opportunity, and it was a pleasure to see you on screen also. Stay home, stay safe. Thank you.
Thank you, sir. And let me add on, it was a pleasure on our part also to listen to you. Such an informative lecture. I had been there for your PhD Viva, and I still have those memories with me, the points that you highlighted, and pertinently how MTP is independent from PC&PNDT, but people mix it up, and what confusions and problems it has been, or even about genuineness of record. I remember all those points. Even I remember how you had traced about, and you referred in the today's webinar also, that particular belt in Maharashtra, there is more access to technology, how it has an impact on sex selection and sex determination of the fetus. Sir, there is one question. Uh, yeah, okay. If you
Go ahead, go ahead. We are having 4 minutes minimum.
yes, sir. So just one. There are a number of questions. I'll just ask this. What is the role of judiciary in implementing the act?
Okay, very simple. The judiciary will have to interpret the provisions of the law. So therefore, don't forget, judiciary is having a limited role, but the change of mindset can be triggered by judiciary. So therefore, if the judges are convinced, they may set the ball in motion. They may trigger change of mindset of the society. Next one.
Yeah. The other one is post-pandemic. Have there been any changes or amendments to the act?
So far, no. We are expecting some better amendments. It is possible in the near future. Next one, please.
Uh, uh, sir, is the conviction rate low?
You are right. The conviction rate is low overall India. We have seen that. But since these offences are documentation based offences, and since the burden of proof is shifted on an accused, so therefore, speaking for state of Maharashtra, the conviction rate is much better as compared to other offences. But still, the overall conviction rate creates a alarming situation, and therefore the answer would be in the negative. Next one, please.
So that's it. I don't want to eat up on your time by 5:30. So if with your permission, can I propose the vote of thanks?
Very well, no difficulty. Somebody has asked something new. If you wish, you can add.
Yes, any of the participants, a resource person has given the chance to you. Anybody wants to add something? Sir, there is a question from Anil Kumar Sharma. He says that such evil practice is still there in our society. How could it be uprooted completely?
See, change of mindset is a long process, so therefore use the technology, use the legal process for changing the mindset. So therefore the answer is twofold. One, changing of the mindset by using different method. Two, use of the legal process for the purpose of changing the mindset. As a student of law of School of Law of Ajeenkya Patil University, you can use this topic for your internal examination purpose. There can be moot court on this topic. There can be a competition about this. For the legal aid centers, you can use this topic. There can be some kind of a disciplinary competitions on this. There can be several innovative methods which can be introduced for the purpose of spreading awareness about this concept, and I'm sure in near future there will be a positive outcome. I think that's the last one. Now you can
Yes.
propose vote of thanks. It's a 529.
Yes. So just a minute, I would like to add on. Like you suggested, for the LLM students, we already have an evaluation based on what is presented by you, and we have asked for reports from them. And that is surely going to contribute to their knowledge. Thank you, sir.
Very good initiative. All the best.
Yeah. So on behalf of School of Law, Ajeenkya D.Y. Patil University, Pune, I express my heartfelt gratitude to Dr. Uday Varunjekar sir for sparing time from his busy schedule and gracing the occasion and sharing such an informative, thoughtful webinar lecture on sex selective elimination and PCPNDT Act its implementation. Thank you, sir. We would like to hear from you again in future. Physically, we surely will be there.
Thank
Be
you,
well, sir.
everybody. Stay home, stay safe. Thanks a lot.
Thank you, sir. So you can log off. I have some, yeah, participation participants. There has been a feedback link sent in the chat box. Please fill it up. You all will get the certificate accordingly. Any doubts? I'm sharing the link again.
Ma'am, my problem, if you remember, my email address is wrong. I had posted in the form. So, like, if you can give me separately, it's okay. Like, no, if you
No,
can give the details,
Mamta, you can do one thing. You can
yeah.
directly fill up the feedback form. No issues.
Okay. You sending a link of the feedback form because I'm on the mobile. Last time
Yes,
you
yes.
sent.
I'll
Yeah.
send it. I'll send it.
Thank you
Yes.
so much. Thank you.
Thank you,
Ma'am,
all
for
of
me
you.
too, can you send on that WhatsApp group because I'm also from the mobile. Thank you, miss.
Sure, sure. I'll send it. Thank you, all of you. Take
Thanks,
care.
ma'am. Have a good
Stay
day.
safe. Stay healthy. All of you have a good day. Bye.
Thank you, ma'am. Thank you.
Thank you.